The relationship between the employees and a company, a design company per se, is very, very important and often overlooked and misunderstood. It's quite common that we get a client, for example, that comes to us and says, we want to assert copyright in a particular thing. It's done by someone we subcontracted the work to, and we come and tell them, unfortunately, you don't actually own the copyright in that particular drawing. And this has got to do with how the rules of copyright and who's the first owner of the copyright. Under a typical employee-employer relationship, the employer will always own the copyright. However, if the work is subcontracted, for example, to an architect, it's quite possible that that architect will own, or an engineer will own the drawings and not you, even though you've paid for it. It's therefore very important to regulate that with the contract. So when you do make over the payment and you receive the payment, you actually get him or her to assign the copyright to your company. In addition, within an employee space, although the general rule is that the employer will own all copyright in the course that's created in the course and scope of that person's employ with the company, it's also important to put that in your employee contract when they sign up for the company, just to make it absolutely sure, not only that you automatically own it, but if there is anything that you may have missed out, that they agree to assign it over to you on your request. And I cannot stress this enough. One, it's misunderstood, and two, a lot of people do not know, whether it comes to designing a logo for a brand, and they outsource that to a design company, that the design company will own the copyright in that brand, as generally.